On the morning of December 13th, 2013, Deputy Ivan Rodriguez of the Monterey County Sheriff's Department responded to a 911 call reporting a suspicious man inside a residence in Carmel, California. After inspecting the property, Deputy Rodriguez found no signs of a break-in. Shortly afterward, the tenant of the home, Air Force Captain Nicholas Ano, opened the front door and asked why the deputy was on the property. Believing that Captain Ano generally matched the caller's description, Deputy Rodriguez detained him in order to verify his identity and confirm whether he lived at the residence. Captain Ano showed his military identification, but did not hand it over to the deputy. The encounter escalated into a physical confrontation, during which Deputy Rodriguez forced Captain Ano to the ground, handcuffed him, and placed him in the patrol car while continuing the investigation. Captain Ano later alleged that Deputy Rodriguez searched his wallet for identification and entered the home without consent to obtain proof of residency. Once his residency was confirmed, Captain Ano was released on July 28, 2014. Captain Ano subsequently filed a federal civil rights lawsuit against Deputy Rodriguez and the Monterey County Sheriff's Department in the United States District Court for the Northern District of California, alleging constitutional violations and related state law claims. As the case progressed, both parties filed motions for summary judgment. Under Rule 56 of the Federal Rules of Civil Procedure, summary judgment allows a judge to decide a claim as a matter of law when there is no genuine dispute of material fact. In his motion, Deputy Rodriguez asserted the defense of qualified immunity, which protects officers from personal liability unless the law was clearly established at the time of the alleged misconduct. On September 29, 2016, Judge Edward Dilla issued an order partially granting and partially denying both motions for summary judgment. The court denied Deputy Rodriguez's request for qualified immunity, citing unresolved factual disputes. Deputy Rodriguez then filed an interlocutory appeal to the Ninth Circuit Court of Appeals, seeking immediate review of the qualified immunity decision before the case was fully resolved at the trial court level. Oral argument was scheduled for September 12, 2017, before Judges Alex Kaczynski, Michelle Friedland, and Mark Bennett. Deputy Rodriguez was represented by Monterey County Deputy Counsel Michael Philippi, while Captain Ano was represented by attorney Nina Paidan. Because Deputy Rodriguez initiated the appeal, his counsel was given the opportunity to present oral argument first.
Good morning, Your Honors. May it please the Court, my name is Michael Philippi. I'm Deputy County Counsel for Monterey County, and I represent the defendant and appellant, Ivan Rodriguez. We've asked the Court to look at the District Court's decision with regard to a decision on a motion for summary judgment. We're contending that the District Court erred in the analysis when it looked at the question of qualified immunity. The Court seemed to stop at the decision of saying, well, there's a dispute factually as to whether or not we can say as a matter of law there was excessive force, or there was an unreasonable length of detention, or there was a Fourth Amendment violation in search of the wallet. The next step in that analysis with regard to qualified immunity would have been to say, okay, we're going to give the plaintiff the benefit of the doubt on the questions with regard to fact, which is the standard for summary judgment review, but then we have to look at, would a reasonable peace officer say, I believe my actions fall within the law? To do that, you also have to look at whether or not the law is clearly defined.
Why wouldn't the answer here have been no to that question? I mean, there was no reported crime, certainly no crime of violence.
There was a 911 call of a suspicious person inside a house.
Suspicious person inside the house. That's not a crime.
No, it's not a crime, but...
I'm sorry, beside the house, right?
Well, the point is, an officer is going to respond to a 911 call. He gets some corroborating... Certainly respond to a 911 call. But the fact that somebody makes a 911 call doesn't enhance the facts in any way. The fact of the matter is, the caller saw nothing that looked like a crime. It's just some guy outside the house, the way you and I might be around our houses, right? And then goes in. There's absolutely nothing like that. Then the officer approaches Mr. Aquino, and he does nothing suspicious. He does nothing illegal. There's no
evidence of anything like that. And then the next thing he knows, Mr. Queen is on the ground losing consciousness. I don't know why you're here. Why are you appealing this case? I am a little baffled.
Because the district court didn't complete the analysis with regard
Well,
to
go ahead, complete it. I just don't see what there is to complete. I mean, officers shouldn't be violently attacking people outside their own houses and then sticking them. I'm talking.
Yes, sir.
I mean, do you want to just waste your time?
No, I don't want to waste my time.
Well, that's what you're doing.
We're here on de novo review, so it doesn't really matter what the district court said exactly. What matters is whether your clients are actually entitled to qualified immunity. And so far, you haven't told us why they are.
All right.
I mean, you've spent a lot of time talking.
During oral argument, Mr. Philippi attempted to highlight what he viewed as a flaw in the district court's decision. In response, Judge Friedland explained that the appellate court was conducting a de novo review. A de novo review is a legal standard under which an appellate court examines an issue anew, applying the law independently rather than deferring to the reasoning of the lower court. As explained by the United States Court of Appeals for the Ninth Circuit in its 2017 decision in Davis v. United States, appellate courts review a district court's grant or denial of summary judgment using this de novo standard. In practical terms, this meant that the focus of the appeal was not whether the district court's reasoning was correct. Instead, the key question was whether, based on a record viewed under the summary judgment standard, Deputy Rodriguez was entitled to qualified immunity as a matter of law.
If the law is not clearly established, the officer is given the benefit of the doubt if a reasonable officer can believe his or her actions fall within the law, even if they're mistaken.
We do know what the law is. What you haven't told us what it was that the reasonable officer saw that would have justified knocking down Mr. Aquino and then locking him up in a police car for half an hour. What is it? I mean, start talking.
All right.
You're already halfway through your argument. You haven't come up with a single thing.
He responds to a 911 call. He's directed to the house, which was also identified in the 911 call. He goes on the property. As he's determining whether or not there's any signs of forced entry, someone inside the house closes the blinds. He decides at that point he's at risk. He's going to withdraw. Someone from the house comes out that matches the 911 call individual and
asks if he needs help, right? I mean, what criminal comes out and asks the police what they need?
Well, if you're trying to divert the attention of the officers so your compatriots can get away or a little child can be slaughtered in the back bedroom, that's a perfectly good way to defer that person's attention away from what's
why isn't
happening.
the thing to do, if you really think that there are criminals inside and there's crime going on, why wouldn't a reasonable officer call for backup?
Backup was on the way.
And wait for backup? To deal with the situation rather than physically attacking a homeowner outside of his own home.
Well, he was
I mean, if
retreating.
it happened to you, would you feel this was justified?
If it happened to me, I would have given him my identification.
Well,
the officer,
he did give identification.
No, the officer or the individual pulled out a wallet and pulled out a card and held out a card that said, "This is my identification." When the officer tried to inspect that identification, he withdrew it. So under the totality of the circumstances, the officers...
Withdrawing the identification is a justification. I mean, that's not illegal. I mean, the officer can look at the ID in his hand, doesn't have to take it.
He wasn't given that opportunity.
So he could say, let me take it.
Well, he held out his hand implying, let me have a look at the ID, and instead the individual withdrew the ID. And under the totality of the circumstances, the officer at this point has reasonable
Says,
suspicion.
okay, I'm going to knock you down because you withdrew your ID.
Well, he was told...
I can't believe you're standing there making an argument.
I believe that he is entitled to
And what justifies then putting him in the police car for half an hour?
He was in the police car for less than half an hour, but even if he was in the police car for half an hour, the courts have already determined...
I'm sorry, let's focus on that. He says half an hour.
Okay.
Okay. And you've said you give the plaintiff the benefit of doubt as to the facts, right?
As to the violation, yes.
Well, as to all facts. I mean, if there are disputed facts, we have to assume plaintiff's facts.
Okay.
So why are you arguing with me when I say half an hour, you say it was less than that? What is the significance of doing that?
Well, the courts have said, and there is a case directly on point where the court has said 25 minutes is not an excessive amount for a detention.
I
But
understand.
he says it was half an hour, so don't we have to give him the benefit of the facts at
All
this
right.
stage in the litigation?
There are other cases that even go farther than that say you can be put in a police car, you can be transported across town and presented for identification with somebody else,
All
and
right,
then
but
transported
my
back.
question is, I said half an hour, and you disputed that. You must have had some reason for doing it, some justification. We have to accept, for purposes of this appeal, it's half an hour.
Okay.
Not okay. Yes or no?
Yes.
Okay, so why did you dispute this? Why when I said half an hour, did you think it was appropriate at this level, in this argument, to dispute the half an hour?
My apologies. There is.
I'm asking you why you did it.
I-
Why did you do it? What is the significance of it?
There is a CAD report, which is generated by an.
I'm sorry?
A CAD report. It's a radio transmission. It logs the radio transmissions from the point of the 911 call to the point
Judge
that the
Alex
entire
Kaczynski questioned Mr.
situation
Philippi
is
about
cleared,
why he was
and
disputing
that
the length of
shows that
time
it was
Mr.
less
Ano
than half an
remained
hour.
in the
It shows
police
that it was
So you want us
25
to
minutes.
dispute?
Judge Kaczynski emphasized that for purposes of a qualified immunity analysis, the facts must be viewed in the light most favorable to the plaintiff. Mr. Philippi acknowledged this point and apologized for the error. As the Supreme Court of the United States held in its 2001 decision in Saucier v. Katz, a court must view the facts in the light most favorable to the party alleging the constitutional injury when determining whether an officer's conduct violated clearly established law. At this stage of the proceedings, the court assumes the plaintiff's version of the disputed events to be true, rather than weighing competing accounts or judging credibility. Accordingly, for purposes of the appeal, Mr. Philippi was required to accept and argue from Mr. Ano's version of events. He could not ask the court to resolve factual disputes in Deputy Rodriguez's favor or reinterpret the evidence to support the defense.
My error, Your Honor, and I apologize.
Counsel, I want to ask you about what the district court characterized on page 9 of the opinion, the extended physical seizure. And you didn't refer to it by name, but I know you know the case, the Gallegos case.
Yes.
And the district court judge cited it several times in the opinion. And what I want to know is, do you think the district court judge didn't give proper weight to the Gallegos case or misapplied it in some way?
I think the court didn't give it proper weight. I think that in that situation, you had an individual who, as I referred to, is stopped, transported across town for a lengthy period of time, is in handcuffs, was stopped at gunpoint, and was determined not to be the individual who was trying to break into the house, so was transported back to his vehicle, which took a substantially longer period of time, was a substantially more intrusive stop, and yet the court said that that's not a violation of the Fourth Amendment. And here we've got a situation where an officer responds to a 911 call. It's not his decision to make the stop. He responds to the 911 call. An individual that matches the description shows up out of the house. There's an exchange. He's told he's being detained, and then he resists the detention. At that point, it's no longer a detention. It's a resisting arrest situation. The officer then...
I'm sorry, why was he being detained? I lost track of that.
So that the officer could complete the investigation as to whether or not he was actually the renter of the home.
I'm sorry, this is after he knocked him down?
This was before they had the confrontation.
And what did he do that was inconsistent with being detained? I'm just losing track of the
I'm sorry, when you
narrative
say
here.
inconsistent.
He didn't walk away. He didn't walk away. He didn't. I'm just wondering, what is it that justified putting him in the police car? I mean, he says you're detained. Okay. Does he do something that's inconsistent with being detained?
The officer wants to place him in handcuffs for his safety because his backup has not arrived at that point. The individual resists being handcuffed. And so at that point he says...
That's a fact dispute too, isn't it? He says he just fell.
He says he was dragged to the ground. So if you
No, but I think he disputes that he resisted being handcuffed, doesn't he? I thought he did.
He said he was complying, yes.
Okay, so again, why are you doing this? Why are you arguing, after you concede, after you state that and you understand the legal framework, that we accept the plaintiff's facts, we have to accept the plaintiff's facts, why are you now arguing things on the other side that's inconsistent with that. Is that professionally appropriate? Is that being candid with the court?
I believe that the analysis for qualified immunity still requires the court to make a finding that says the officer was not reasonably justified in believing his actions.
But we have to
fell
accept the
within
facts
law.
on the ground as plaintiff alleges them. And plaintiff says, I complied. Why are you arguing he didn't comply? Why? How can you stand there
I'm not saying
as
he
an
didn't comply.
officer of the court? And I'm sorry?
I'm not saying he didn't comply.
But you just did. You just said exactly that. You know, this is on tape.
Okay.
Okay? So you should go back and look at it, and I think you should have your supervisor look at this. You understand?
I do.
I'm directing you to, who's your supervisor?
Susan Blitch.
I couldn't hear you.
Susan Blitch.
Susan what?
Blitch. B-L-I-T-C-H.
Okay. You will ask her to watch this argument and see whether making the kind of argument you do is she thinks is appropriate.
Okay.
Okay? We'll hear from the
After the time allotted for Mr. Phillippe's oral argument
May
expired,
it please the court?
Ms. Nina Paitan
always
was given
like
the
that?
opportunity to present oral argument on behalf of Mr.
My
Nicholas
name's Nina
Ano.
Patani. I'm here for plaintiff appellee Nicholas Aquino. I'm very moved by some of what I heard today. This has been a bit frustrating. It is our position that appellant's appeal is frivolous and serves only to delay justice to plaintiff appellee.
Are you seeking attorney's fees for that appeal?
We are. My reasons for stating so is that jurisdiction is defective, as explained more fully in appellee's brief, for a variety of reasons, including that the district court found that there were disputed facts that required assessment by a jury, and it would be therefore premature to make the final decision on qualified immunity. I think the court also implied that if it accepted all of the facts in plaintiff's favor, it would not find this officer's conduct reasonable. I don't believe there's jurisdiction at this stage, and I don't think there's jurisdiction to assess the search of the wallet claim because I think that issue was waived.
I'm having trouble understanding your jurisdictional argument. I mean, they're entitled to accept plaintiff's facts. I realize they don't do that, but they're entitled to accept plaintiff's facts and they still say there is no disqualified immunity. And we have jurisdiction to hear that. I don't understand how you can argue there's no jurisdiction.
Well, I think that's a good point, Your Honor, and I think there's
It's really more of a question.
It's a question? Okay.
Yeah, I mean, how can there not be jurisdiction? I mean, we can say they're wrong, and I think they are wrong myself, but the fact that they are wrong doesn't deprive us of jurisdiction.
Well, I think in ACT UP v. Portland and in Johnson v. Bay Area Rapid Transit, 2 Ninth Circuit cases, and also in Johnson v. Jones, which is a U.S. Supreme Court from 1995, there is an indication that an interlocutory appeal on a denial of qualified immunity that was based on disputed facts in the categories of what the officer believed or perceived, and in the category of what actually transpired between the officer and suspect, that those types of fact determinations were so highly fact-specific and subject to credibility determinations and inferences that they were more appropriately decided by a jury.
So your opposing counsel has made such arguments, and that muddles this up, but to the extent he's also arguing that assuming plaintiff's facts there would be qualified immunity, which I think probably charitably read his briefs also argue, we have jurisdiction over that type of argument, don't we?
Sure. I mean, I think
It's probably a loser, but not a matter of jurisdiction.
Okay.
You're willing to take a victory any way you can, right?
I think that the jurisdiction issue for us is more something that we thought contributed to our sentiment that this appeal was ill-advised. It was just one more reason it was ill-advised, because there are indications that jurisdiction is premature.
I think Mr. Phillippe is coming around to that view.
Okay. And then the second reason we think the appeal is frivolous is that the law setting forth legal parameters for a Terry stop has been very well developed, well settled, and clearly established by this circuit in addition to other circuits.
So can I ask you a question about that? So I really only have one question for you that I'd like you to help me with, which is this Gallegos case. I think you can distinguish your case from Gallegos such that maybe we could say there is a constitutional violation here when there wasn't in Gallegos, but I'm having trouble understanding why Gallegos doesn't create enough uncertainty in the law to have there be qualified immunity on the investigatory stop part of your case. You have a lot of other claims, but on the one part about whether the police could detain him for long enough to figure out if he was the right person or was a criminal, it seems like Gallegos was very broad in saying what police could do to investigate something and detain someone in the meantime. And I wonder if it creates enough uncertainty in the law that there would be qualified immunity on that claim.
And I don't think it does.
Judge Michelle Friedland questioned whether the relevant case law created sufficient uncertainty for qualified immunity to apply to the claim arising from Mr. Ano's detention. This line of questioning went directly to whether the law was clearly established at the time Mr. Ano was detained. As the Supreme Court of the United States explained in its 2011 decision in Ashcroft v. Alkid, the clearly established prong of the qualified immunity analysis asks whether, at the time of the incident, existing law placed a constitutional question beyond debate. In other words, the standard requires that every reasonable officer would have understood that the specific conduct at issue was unlawful. Although this standard does not require a prior case with identical facts, existing precedent must clearly establish the unlawfulness of particular conduct being challenged. The law also cannot be considered clearly established at a high level of generality, such as the broad principle that a Terry stop must be supported by reasonable suspicion. In this context, Judge Friedland was probing whether the relevant precedent left room for reasonable disagreement about whether Deputy Rodriguez's detention of Mr. Ano was lawful.
Gallegos is one of dozens of cases that talk about when an officer may exceed the traditional parameters of a Terry stop.
So can you point to a case that has facts that are more similar to this one than Gallegos? Because Gallegos is somewhat similar.
Actually, it's not similar. In Gallegos...
Okay, can you point to another case than Gallegos that will help me see why you think they can't stop him like this?
Why they can't stop him? Johnson v. Campbell would be the best. It's out of the Third Circuit.
Okay, how about this court?
This court would be U.S. versus Delviso, U.S. versus Ricardo D., Washington v. Lambert, U.S. v. Miles, United States.
Can you tell me why you think they're more similar to the facts here than Gallegos?
Yes, because in cases, all of the cases where intrusive means have not been allowed are more like this case. In other words, Delviso. Delviso involves a case where a car is pulled over and the suspects are ordered out at gunpoint. Delviso's ordered out at gunpoint, told to get on the ground, and cuffed.
And had there been a tip, like a 911 call in Delviso?
Delviso, the suspect had been under surveillance for drug trafficking. And in Delviso, the court found that those tactics constituted an arrest because they exceeded the bounds of Terry.
So in Delviso, there was more than a tip. There was actual evidence of an actual specific crime.
They had been surveilling Mr. Delviso because they thought he was part of a drug trafficking program. And when they pulled him over, they ordered him out of the car at gunpoint, I think told him to get on his knees or the ground and cuffed him. The court found that was a de facto arrest. That was not a Terry stop because there was no indication that Mr. Delviso was armed, had just there hadn't just been a violent crime. There wasn't information suggesting that he was about to commit a violent crime. There was no information that he was carrying a weapon. And because we did not have...
I'm looking at Delviso, so I apologize for not remembering exactly, but it seems like the Delviso issue was, it says, there was no evidence suggesting that Delviso was particularly dangerous, especially once he had stepped out of the van, had been frisked, and was lying on the ground. So I'm not sure the court thought it was improper to stop him. The issue was just that after that, they drew their weapons.
They did not think it was improper to stop him.
So how does this help you with the seizure of your client here for some time while they investigate? I mean, no weapons were drawn.
There is no authority that I have found in this case, this circuit's precedent or any other circuit's precedent, that allows a citizen to be stopped and held just because an officer needs to investigate something.
Except that's kind of, I mean, isn't that what happened in Gallegos?
Well, no. Gallegos was a situation where a violent crime had occurred, first off. And minutes later, the officers in a chopper see a man walk out of the victim's home, or near the victim's home, get in a car and flee. The man matches the description of the man who tried to break into the house. So the officers have reasonable suspicion to stop the person. There's been a report by a victim of an actual crime, a violent crime. Somebody's trying to break into my house. I have a restraining order against them. I fear for my life and limb. After that report, the officers who are overhead see a man matching the description flee in, I think, a pickup truck or a vehicle of some kind.
He's not fleeing, right? It turns out he's not even the person.
Not
so he's
fleeing.
He's driving away.
Right. But a crime has clearly been reported, and it's a crime that threatens life and limb. So the officers have reasonable suspicion that criminal activity is afoot. They think this man is part of it. So they stop him. And they stop him by ordering him out of the truck at gunpoint. He complained not that this wasn't a proper Terry stop. He complained that those were excessive measures because I'm not armed, I'm not even the right guy. I think what the court was saying is, well, there had just been a violent crime. You were believed to be the right guy. You were believed to be fleeing, and these beliefs were all reasonable under the circumstances.
So I think you're making a good argument about why we could say there's a constitutional violation in this case, but not, even though there wasn't in Gallegos. But isn't it close enough that a police officer could think Gallegos meant that they could stop someone while they investigate, especially if they don't draw their guns? I mean, it's at least, it seems at least arguable to me, which I think is what qualified immunity is about.
I don't think so, Your Honor, because I think Gallegos is taken out of context. There are too many cases authored by this court that lay out the parameters of a proper Terry stop.
Isn't one of the distinguishing factors of Gallegos that this man is outside his own house?
Sure, yes.
So this is not somebody that's on a highway, on a street, or traveling in a car. And at that point, what do you do? Then they could get behind the wheel and drive off.
Did they know, though, at this point that it was his house? I mean, they were following a tip that someone...
He came out of the house, right?
He was seen crossing the street and entering a vehicle right outside of the subject house.
But in your client's case?
In my client's case, there's not even a report of crime. In my client's case, you have a third party.
But he is seen coming out of the house.
My client?
Yes.
Yes, Your Honor. He is seen coming out of his house after having...
But this is not a highway situation where he's in a highway and he's got a vehicle. Is there a vehicle involved?
There's a vehicle involved in Gallegos.
No, in this case.
No. There is no...
So it's not like he's about to drive off. He's about to...
There is not a single scintilla of evidence that my client is attempting to flee or leave. Not a scintilla. There's not a scintilla.
He's on the ground, partly, sort of recovering from being...
He was attacked because he did not place the contents of his right hand, which was his military ID and his wallet, into the palm. This was done. He didn't do this. And he got attacked. And my point is that Gallegos bears no similarity.
Right, but we're talking about the detention after the attack. We've got the attack, and that's one issue. And then he gets placed in the police car, right? He tries to handcuff. Are there any further facts that justify that?
No, because all intrusive means, any intrusive mean on a Terry stop, has to be justified.
I mean, he's not getting up and running away.
Right. So all intrusive means on a Terry stop have to be justified by the Washington versus Lambert factors or by other factors that maybe haven't been developed yet that contribute to a reasonable belief that the officer or some other party safety is threatened or that the person is going to flee. There's just no justification on a Terry stop for handcuffs, force, or restraint outside of specifically identifiable circumstances that put the officer's safety at risk or somebody else's safety. Like in Gallegos, I think, the court did not elaborate a lot because I don't think they saw it as a close call, and I think appellant relies a lot on dicta. But Gallegos did involve a situation where the victim caller, was feeling threatened for life and limb and said that a restraining order was violated, and she thought her father was going to try to hurt her. So there was a sense that this person, the suspect, that yes was misidentified, but they don't know that this person is a threat to not only potentially the officers, but to this victim. So Gallegos is just that I think the appellant's reliance on Gallegos shows how little authority there is for their position, because it is not remotely close to these facts. Is that enough, or shall I continue?
No, we are out of time.
We're out of time. Oh, okay.
Out of time.
Okay. Well, thank you, Your Honor.
Case just will be submitted. Mr. Philippi, I see that the county counsel is Charles McKee. We'll have him watch the argument as well.
On October 11th, 2017, the United States Court of Appeals for the Ninth Circuit issued an opinion affirming the denial of qualified immunity. The court also ordered Deputy Rodriguez to show cause in writing within 14 days why sanctions should not be imposed under Rule 38 of the Federal Rules of Appellate Procedure. Rule 38 permits a court of appeals to award just damages in single or double costs to the appellee if an appeal is deemed frivolous, meaning wholly without legal merit. Both Deputy Rodriguez and Mr. Ano submitted written arguments addressing the potential sanctions. On November 20th, 2017, the court issued an order concluding that Deputy Rodriguez's appellate arguments were wholly without merit as to all but one issue involving costs. As a result, the court deemed the appeal frivolous in all other respects and ordered Deputy Rodriguez to pay Mr. Ano's reasonable attorney's fees and double costs associated with the frivolous issues raised on appeal. On April 26, 2018, the court awarded $94,328.50 in attorney's fees and $90.50 in costs to Mr. Ano. Meanwhile, because the Court of Appeals affirmed the denial of qualified immunity, the lawsuit proceeded to a jury trial in the United States District Court for the Northern District of California. The trial began on July 31st, 2018, and concluded on August 13th, 2018, when the jury returned a verdict finding that Deputy Rodriguez had violated Mr. Ano's constitutional rights and used excessive force during the detention. The jury awarded $1 in nominal damages for the unlawful search, no compensatory damages, and $200,000 in punitive damages. Both parties indicated their intent to file post-judgment motions, including motions for a new trial. However, on October 5th, 2018, the case was dismissed after the parties reached an undisclosed settlement that fully and finally resolved all remaining issues. This case illustrates the real-world consequences that can follow when an appeal crosses a line from aggressive advocacy into litigation lacking legal merit. Appeals are costly, not only for parties involved, but also for taxpayers. Rule 38 exists to prevent the waste of limited judicial resources and protect litigants from being forced to spend money responding to baseless appellate arguments. Interlocutory appeals, in particular, can halt proceedings, delay trial for months or even years, and increase pressure to settle for reasons unrelated to the merits of the case. Rule 38 serves as a counterbalance to that dynamic by reinforcing that the right to appeal is not a license to litigate irresponsibly. It ensures that when an appeal is frivolous, the financial burden does not automatically fall on the party forced to defend it. Here, after affirming the denial of qualified immunity, the Ninth Circuit determined that all but one of Deputy Rodriguez's appellate arguments were wholly without legal merit. Consequently, the court required Deputy Rodriguez to pay Mr. Ano's reasonable attorney's fees and double costs for frivolous portions of the appeal, ultimately awarding nearly $100,000 in fees and costs. This decision highlights the significant financial consequences of abusing the appellate process by pursuing appeals without a sound legal foundation, consequences that both compensate the injured party and deter others from bringing similarly unfounded appeals. If there is a case or courtroom interaction you would like us to explore, let us know in the comments below. Thank you for watching, and don't forget to like and subscribe as we continue working to foster a more informed society.